Okay. Are you all set?
Yeah.
All right, we'll call the case of People versus Derek Lee Morose, file 253500 SM1. Date and time of sentencing. Did I pronounce your name correctly, sir?
I believe so.
Okay. So Mr. Morose is here with Mr. Traeger. The conviction here is child abuse, leaving a child unattended in a vehicle. There's a recommendation for delay of sentence. So, Mr. Morose, have you had the chance to review this report with Mr. Traeger, sir? All right. Is the report factually accurate, or are there any changes, corrections, or additions to make to it?
It is accurate. We have no changes, corrections, or additions, Your Honor.
Okay, very good. By way of elocution, then, are there comments, Mr. Traeger?
Yes, Your Honor. Again, good morning, and thank you for having us this morning. I did want to just point out a few facts from the supplements that PSI, the defense, submitted a number of days ago. We submitted 2 letters on behalf of the defendant, as well as a screenshot or a photograph of some classes that he was taking. Obviously, Mr. Morose is very apologetic for the circumstances that bring him here today. His daughter Agatha is very important to him. That's evident in the letter specifically from his mother-in-law, in which she talks specifically about how incredible of a father he is, being amazing with Agatha, and having several people mention the fact that she seems to be a happy child by virtue of the parents in the home. This was obviously a mistake on Mr. Morose's part to leave his daughter unattended in the vehicle while going inside, but I do think there are mitigating circumstances here. Child had been sick for a period of time. According to Mr. Morose, she hadn't slept for a period of time and was sleeping when he pulled up to the family fair. He thought he could run in and grab a few things. Unfortunately, he does have ADHD or ADD, and therefore, it does have sometimes some issues focusing and can get easily distracted. It appears that that's exactly what happened on this particular occasion. He's a first-time father, which I remember the first few months of being a father myself, and it was significantly different than any life I'd led before. And so ultimately, Mr. Morose is very apologetic, and we think that this is just a blip on the radar in terms of his overall ability to be a father. And so we would agree with the recommendation, consistent with this plea agreement, for the delay of sentence and allow him that year to show the court that he is better than these circumstances that bring him here today.
Okay, thank you, Mr. Traeger. Mr. Morose, are there any comments you'd like to make, sir?
Yes, I'd like to. This, Your Honor, thank you for your time. I want you to know that I love and care about my daughter and wife more than words can express. I never meant to put my daughter in danger, and I wish I could change my actions of that day. It had been a rough week with my daughter recovering from an ear infection. I left her in a car while running into family fair to retrieve Piper, formerly Tylenol. The only reason why I left her there, because she was sleeping sound and I thought it'd be quick. She hadn't slept well that week, so I wanted her to rest. I have been diagnosed with ADD, and sometimes it can be overwhelming. I went into the store and got terribly distracted. I know I should have been more careful, and I understand why people are concerned that my daughter was alone in the car. Since this incident, I have attended parenting classes in Wellsprings, Springs, Traverse City, practice services. I am dedicated to being a better father and husband. Thank you for accepting the plea offer. I'm dedicated to using this year of supervision to show that I am improving. I can promise you today that I will never place my daughter in danger. Thank you.
All right, thank you, sir. I appreciate your comments. I think that you've learned from this experience. You understand the seriousness of an event like this, and I think you've taken appropriate steps to deal with it going forward, and it appears you could be successful on the delay of sentence. So I'll order 365 days of probation with the delay of sentence, a $100 fine, $800 court costs, $75 crime victims fee, $50 state fee. And while on probation, may not have any violations or be charged with a new crime. If either of those things had happened, prosecutor probably wouldn't grant the delay at the end of 1 year. Not to behave in a violent, threatening, intimidating, or harassing way toward anyone. Be respectful of all court employees, service and care providers. Provide a list of your prescriptions to probation within 48 hours. Continue and complete the always a parent class through CPS, provide verification of probation that you're in the class and that you've completed it. 10, cooperate, complete, pay the fee of the love and logic parenting class. May not leave your child unattended for any reason. 3 days of community service work, credit for time served. And if you have contact with law enforcement on probation, you need to let your agent know about that. But I think you could be successful here. And again, I believe that this is a big learning lesson for you and it won't happen again, okay? All right,
Thank you, Your Honor.
thank you. All right, so I'm gonna mute for a second. So the conviction here in Mr. Burgess' case is use of methamphetamine and attempted possession of a loaded firearm in a vehicle. Mr. Burgess, have you had the chance to review this pre-sentence report and the substance use assessment, sir?
Yeah.
Are these documents factually accurate, or are there any changes, corrections, or additions you'd like to have made?
No, sir.
The documents are accurate, factually? Okay. All right, by way of elocution then, are there comments, Mr. Graff?
Oh, yes, please, Your Honor. I guess just before elocution, I guess as a correction, it looks like there may be a typo under employment, says, looks like B. Roy's, it's probably should be Burgee collision.
Oh, okay.
And I guess just trying to inform the court of his wages. Apparently the business brings in approximately $69,000 a year, which equates to about $20,000 of wages for Burgee.
All right, so make those additions. Okay, any comments then, Mr. Graff?
Yes, please, thank you, Your Honor. Your Honor, as we'll see, Mr. Burgee is 58 years of age. It's been quite some time before he's really been in trouble. He racked up quite a record in the 80s, seemed to turn his life around, and unfortunately had a run in 2013, 2017 involving marijuana. Since that time, it's my understanding he's got his medical marijuana card. Unfortunately, it seems that he still finds himself coming back to this court under a very dangerous situation. Anytime you have a firearm involved and you had controlled substances, it's very scary. Luckily, this was not a situation in which he was doing anything else nefarious. He was driving down the road. They pulled him over. He was honest about obviously everything that they found in the car. Informed them that they thought that the dog was in the back seat. He was cooperative. I think in one sense he's learned a valuable lesson that you need to be more cognizant of your surroundings. Obviously, he indicated that somebody had left the methamphetamine in the vehicle and he forgot about the firearm. You just can't forget about a firearm, especially if it's loaded. You need to know where that is and have that properly cased as well as transported. And so it's an unfortunate situation, again, why we're here, because it seemed he had really turned his life around. He's a very talented mechanic, as I understand things. He's a certified Cummins diesel mechanic. He's a transmission specialist and he's a certified welder. So he's got a lot of skills. His fear is obviously, given the limited income he has from his business, if he were to be incarcerated, he may lose everything. I think he knows the stakes are very high, given some of the issues that have been brought to the attention of the court and the PSI regarding bond performance. And so I think he understands that probation, it could be a tough road, but I think there could be many benefits. I agree with the PSI that maybe going back and getting a new assessment and disclosing all these issues that have happened on bond might be appropriate in order to make sure they get the proper level of care. I think that obviously that was even noted in the recommendations from the assessment was if there are any issues, if he were to fail a PBT or urine screen on bond or probation, he should prefer for further assessment. So I think obviously those coincide that there is a question here of what's been going on. He's adamant about what he has and has not consumed. He brought a bag of medication with him today to show the court what he's been taking, and he's adamant to me that he was not consuming the substances that he tested positive for. In fact, I think he went and got a confirmation test for the last test because he was confident that it wouldn't come back positive. And so I'm not sure what exactly is going on that end, but the court will find out on probation that if these things persist, they can more likely assume that it's probably use as opposed to misunderstandings or some type of medication issue or just not knowing what you're taking, which I think is also a good thing, because if you have health concerns and you're 58, you need to be more cognizant of what you're putting in your body. Obviously, this shouldn't be happening. If you have health concerns, certainly anything that's out of the norm could create additional issues for you. And so I think that moving forward, Mr. Burgee knows that he's going to be under the microscope, but I think that at the end of this, he'll be much better off after found in terms of probation. It was unfortunate that he wasn't able to conduct the full interview, but he did provide the paperwork and show up that day. And because he wanted to make sure the probation department got his information, he was turned away, he couldn't have the interview. He did provide a written statement. So this is somebody who's been obviously trying to be compliant. He showed up. Obviously, if he would have concerns or known about the warrant, he could have just blew it off and said, catch me when you do. He showed up today knowing obviously there was this issue. So I think he is taking it very seriously. And so I would ask the court in that regard to follow the recommendations. I think the probation would be good for him. Obviously, I don't want him to lose what he has put together in his life at this stage. It could be very difficult to pick the pieces back up and start over again. But also, I think he's very cognizant again that if he doesn't follow these recommendations, if he misses tests, tests positive, doesn't follow through the assessment, isn't candid in that assessment, or has any other issues, given the significance of these charges and his performance, most likely it's probably going to result in a pretty significant jail sentence. At that point, he's not going to have a whole lot to say other than, what do I do about business when I get out? It may not be there. But I certainly do agree that he deserves the opportunity. I think society as well as Mr. Berg would be better off if they received some services. And so I would ask for to follow the recommendation and give him that opportunity.
All right, thank you, Mr. Graff. So, Mr. Burgey, are there comments you'd like to make?
No, sir.
Well, why were you driving around with a loaded 270 in your back seat?
It was the day after deer season. And I was kind of running late that morning to go help my uncle, who's crippled in some cases, hard to walk, trying to help him do a few things and just totally forgot I'd laid it in the back seat.
Well,
I basically hunt from home. And instead of putting it in the house, I just set it in my truck after I returned.
well, if that's.
No excuses, unfortunately.
If that's really, yeah, if that's really what happened, that's very careless and dangerous, like Mr. Graff pointed out. So that's one thing. Then why do you have someone else's methamphetamine under the driver's seat of your vehicle?
It was put under there the day before we were hunting together. He didn't realize he was carrying it and just asked me if he could set it in my truck. And it was totally forgotten about.
Any,
No excuses once again, but that's all I can say about it.
so that person put it under the driver's seat?
He just set it in the truck. Yes, sir. I hunt from home, basically. We walk into the woods from home.
And hunting while on methamphetamine obviously is extremely dangerous as well. So the medication portion of the pre-sentence report indicates medications unknown. Mr. Graff said you showed up with a bunch of medication today.
Just normal stuff that I take for my heart and pain.
All right, so going forward on probation, you have to let your probation agent know exactly what your medications are. Every time you refill them, you need to
That's
let.
why I brought them with me today, sir.
All right, so that's what you need to do. Your statement to probation indicates you've been taking painkillers that are not prescribed to you.
I took one.
Well, in any event, you're taking, on probation, if you take non-prescribed medications, that's going to be a big problem and likely it would be a violation. And what's going on with the cocaine positives?
That's sir, I can't tell you. I show you the medications I take. Other than that, I don't know. I have not done any.
Well, probation apparently asked about the cocaine and you told her that
That
could have been in the
one week,
pills.
that was the one time I told her about the pain pill that I had took. And maybe that's what caused it. I'm not sure.
All right, so let me just ask, Ms. Morton, is there anything you'd like to add in the matter here?
No, just that we had that brief conversation about the medication. Said that he was using somebody else's pills. I did tell him he had a warrant and he was going to turn himself in that day, but I saw that he did not.
All right, so I was going to ask about the warrant. Is that still out there?
Yes, I believe it is.
Oh, okay, so we'll get to that in a second. Probation is recommended to be 365 days. I'll go ahead and order that. But if there is a violation, as Mr. Graff stated, it could result in a long jail sentence. You have up to a year here that you could do. So $100 fine, $800 court costs, $75 crime victims fee, $50 state fee, $700 attorney fee. While on probation, may not consume or possess alcohol, illegal drugs, mood altering substances, no non-prescribed medications, no recreational marijuana, not to reside where alcohol, legal drugs, firearms, or weapons are present, no bars, casinos, or places that serve alcohol by the glass, not to possess firearms or other weapons. Was it a requirement in the statute, with regard to the firearm, Mr. Graff, that the weapon be forfeited?
I believe it was, we also like, agreed to it as part of the
Okay.
waive that we would forfeit the
All
weapon.
right, so the weapon must be forfeited, not to behave in a violent, threatening, intimidating, or harassing way toward anyone, be respectful of all court employees, service and care providers, not to leave the state without the consent of the court, obtain a new substance abuse assessment, follow all recommendations in that assessment, disclose all of your bond violations to the assessor. Again, as Mr. Graff pointed out, that's the way we get the most accurate assessment, such that we can best help you and address what you need help with in terms of drug or alcohol issues. 4 times monthly random drug screens, which can only be taken in the morning, not at night, discretionary drug and alcohol screens. And why didn't you turn yourself in on the warrant?
Because of my business.
Well, so what I'm gonna do, and this is to address the warrant and the bond violations. I'll sentence you to 4 days jail additional starting today. So you'll be released Monday morning at 6 a.m. so you can go to work on Monday, okay? But if there's any other issue with probation, a warrant will go out and you could spend a long time in jail on a probation violation matter, okay? So that's where we are. Anything further, Mr. Brown?
No, I guess just to correct the fees, I was retained, so if we could remove the court-appointed fee.
Could you repeat that? I didn't quite hear.
I was retained, Your Honor, so if we could amend that to remove the court-appointed fee, and save them the $700.
I'm sorry, to reduce the court appointment?
To remove it, I was retained.
Oh, sorry, yes. Okay, there'll be no attorney fee. Anything else?
No, thank you.
Okay, all right. So you're all set, sir. So good luck going forward. When you're released, you're gonna be released at 6 a.m. on Monday, but you need to contact probation, okay, Monday between 9 a.m. and noon to schedule an appointment with Ms. Morton to go over these terms, okay?
Okay.
All right. So for now, you're all set. So again, good luck going forward. Thanks, Mr. Brad.
Thank you. Thanks.
All right. Let's see.
One hand myself, thank you. Well, I just want to hand my medication here.
You're not gonna need to take care of it.
No. I'm tired. Oh, sorry.
You can take yourself. Want to give us a family member?
Yes.
You have any other property?
All right.
Last time, January, but maybe Monday.
Yeah, it could be. Okay, let's just go over here and I'll get you some.
All right. So Ms. Conlon, you represent Jennifer Lowers.
Yes, that's flowers first.
All right.
We're ready.
We'll call that case. It's file 253546 ST1. It's date and time of sentencing. Ms. Lauer is here with Ms. Conlon. Ms. Morton is here for probation by Zoom. Conviction here is operating while intoxicated first, a 93-day maximum misdemeanor. Ms. Lauer, have you had the chance to review this pre-sentence report and substance use assessment?
Procedures.
Are the documents factually accurate, or are there any changes, corrections, or additions to make to them?
Yeah, I just wanted to clarify that. I did not say that I didn't use alcohol. I said that alcohol was not my drug of choice.
And that's referring just to the information at the top of the last page, or the third page. I think Ms. Lauer was honest with Ms. Morton about her prior drug use, but it just said that alcohol wasn't her drug of choice. She didn't deny using alcohol before, just to clarify.
Okay, so I'll make that clarification. Anything else to correct?
I think that's it, Your Honor. Everything
Okay.
else was good.
All right, so by way of allocution, are there comments, Ms. Conlon?
I mean, I approach Your Honor, I just have a treatment verification from Ms. Lauer. She's been going to up north psychology.
Okay,
She lives in Gaylord, so she's been getting services there.
okay, so I'll take that into account.
Your Honor, and Ms. Lauer obviously has a less than ideal record. She'd be the first to admit that it's very extensive. However, I think it's noteworthy that, until this incident, she had been out of trouble since 2018. And she basically has paid her debt to society for what occurred in her past. She knows she made a big mistake on this occasion, shouldn't have been drinking and then volunteered to drive. I think she was pretty open and honest with both the assessor and Ms. Morton about how much she had to drink. She's not trying to hide anything. She did, I think she kind of did turn her life around since her last conviction in 2018. She's employed full-time. She's making decent enough money. She's working on further education in the cosmetology field. She's got 3 kids that live with her. She's taking care of them. So other than this incident, Ms. Lauer in the last few years has been doing quite well. So I think that Ms. Morton has made some good recommendations regarding Ms. Lauer's probationary terms. The only thing we would ask, Your Honor, is in light of the fact that she isn't making a ton of money and she has 3 children living with her, that you consider reducing the recommended fines and costs. The other thing we request, Your Honor, if I expect that Your Honor will want her to continue with UAs. If that's the case, I wanted to put the court on notice that she is going to Chicago April 4th through April 7th for work purposes. She's going to a hair show there. So if the court does impose condition that she can't leave the state as recommended, we'd ask for permission to do that. And also for permission to miss testing on those days if her code comes up, if the court does continue her urine screens.
Okay, so thank you, Ms. Conlon. Ms. Lauer, are there comments you'd like to make?
No, I think she covered them all.
So I guess the only thing I would say is driving with a .195 puts everybody in extreme danger on the road. So I know you've thought about that and talked to Ms. Conlon about that. So I just want to reinforce that. But I think you're addressing these issues appropriately. So it appears you can be successful on probation. And I also agree that Ms. Morton has put together an excellent plan here for you in terms of the conditions of probation. So I'll follow those. Probation will be 365 days. Actually, at the halfway point, if you've done everything that you were supposed to do, you can request early release and it'll be considered $100 fine. I'll reduce the court cost to $500, $75 crime victims fee, $50 state fee, $275 attorney fee, $125 arrest fee, blood fee of $22.30. While on probation, may not consume or possess alcohol, may not use or possess any illegal drugs or mood-altering substances, no recreational marijuana, not to consume or possess any non-prescribed medications, not to reside where alcohol or illegal drugs are present, no bars, casinos, or places that serve alcohol by the glass, not to behave in a violent, threatening, intimidating, or harassing way toward anyone, be respectful of all court employees, service and care providers, not to leave the state without the consent of the court. However, since you've been doing well on bond and addressing the matter appropriately with counseling, etc., I'll go ahead and approve the work trip out of Michigan to Chicago, April 4 to April 7. You'll have to take a PBT machine with you though, okay?
And she has one, Your Honor.
Okay, and then test. So the PBTs are going to be twice daily while on probation. Going forward, those can be reduced if you do well on those. I'll order the 2 times monthly random UAs. I'll grant the request to not have to submit UAs while in Chicago, but I'll order an AMUA on April 8th when we get back, okay?
Yes, sir.
All right, be respectful of all court employees, service and care providers. Let's see. You've already had your substance use assessment.
And what had happened, Your Honor, was Ms. Lauer got one done, in my advice before she led with, CHS and Gaylord.
Okay,
And that hadn't been forwarded to, our probation, but it was subsequently.
okay. All right, and the recommendation is in the assessments to attend outpatient substance abuse counseling, follow all recommendations of therapists there. So, and that's covered in the recommendations here. Okay, so we won't order a new assessment. 2 12-step meetings weekly with written verification, monthly to probation, obtain a sponsor within 90 days, to continue individual outpatient counseling with Jeanette, is it Sayer?
There, yes.
Okay, Sayre, and Ashley Hinton. Provide written verification monthly to probation of your counseling attendance. Again, twice daily PBTs until further notice, twice monthly random UAs until further notice, discretionary drug and alcohol tests, credit for all time served, and then notify probation if you have any contact with law enforcement on probation. But again, you appear to be addressing the matter seriously right from the start of the case, so looks like you can be successful on probation, and if all's going well, at the 6-month mark can be discharged then, okay?
Thank you, Your Honor.
Okay.
Should she call probation this afternoon?
Yes, we'll need you to call probation today between 1 and 3 p.m. The numbers in the pre-sentence report plus Ms. Collins given it to you already, so.
Yes.
That's still from.
Yes, sir.
Okay, so you're all set, ma'am, so good luck.
Thank you.
Thank you,
Sure.
thank you. And do you represent,
Mr. Cerna?
yeah,
Yes.
we'll call the case of People versus Cody Cerna. So this is file 253548, SD 1. Okay, Mr. Cerna's here in person with Ms. Conlon. All right, so the conviction here is operating while intoxicated first, a 93-day misdemeanor. Mr. Cerna, we didn't get a full-blown pre-sentence report from probation because you didn't have a prior criminal record, but we have this no PSI sheet that's been prepared with some brief factual information and then an attached substance use assessment. Have you had the chance to see these documents?
Yes, Your Honor.
Okay. Are they factually accurate, or are there any changes, corrections, or additions you'd like to make?
No, sir.
Okay. So then by way of allocation here, Ms. Conlon, are there comments you'd like to make?
Your Honor, I think that the substance use assessment kind of bears out my feeling that this was an isolated incident on Mr. Cerna's part. Definitely his BAC is cause for concern. But I don't, from the assessment report, plus from speaking with Mr. Cerna, I don't get the impression that this is something that he does often, is goes out and brings to access. I think it was circumstantial. I don't think he brings that often. More than a couple beers, maybe. He doesn't drink that often. The result of the assessment was that he doesn't meet the criteria for substance use disorder. And based on my conversations with Mr. Cerna about what happened, I agree with that. I'd ask that you adopt the recommendation made in the report from Ms. Chubb to just sentence him to fines and costs, no probation, and give him some time to attend the alcohol highway safety education class and the victim impact panel. He's doing well. He's got a good job. So he's probably going to work today, or he just likes to wear that all the time. I think he's doing well in life, and I think this was an isolated incident.
Okay, thank you, Ms. Conlon. So, Mr. Cerna, are there any comments you'd like to make, sir?
No, sir.
All right, well, I agree with Ms. Conlon. I would point out, as Ms. Conlon pointed out, driving with a .17 puts yourself and others at great risk, okay? but I don't see the need for probation based on the assessment. There was not a substance use disorder discovered, very low scores on the testing instruments that were given. So I do believe this is an isolated incident. You've learned from it and it won't happen again. So no probation, $100 fine, $600 court costs, $75 crime victims fee, $50 state fee, $125 arrest fee. There's an attorney fee of $275. I will order the alcohol highway safety education class in the victims impact panel to be concluded or finished within 90 days, okay? And then credit for time served. So as common, we'll give you probation's phone number. Call them today between 1 and 3 p.m. and they'll tell you how to get the classes done, okay?
Yes, sir.
All right, so thank you, sir. Thanks, Ms. Conlon.
Thanks, Ryan.
All right, so I'm gonna mute for a minute here. So we might have some pre-trial
Good morning.
Good morning. We'll call the case of People versus Jose Rivera Jr., file 253612 SD1. There was a pre-trial conference this morning. Mr. Rivera is here in person with Ms. Maas. The original charge was operating at the IDAC, 180-day maximum misdemeanor with driver's license sanctions from the Secretary of State. There is no reduced plea offer, it appears, but the prosecutor would not seek any jail or term of probation. So that is the offer. So do you understand that, sir?
Yes, sir.
Do you wish to accept the offer and plead guilty to operating at the IDAC?
Yes, sir.
All right. And you don't have any prior records, so you're not on probation or parole, right?
No, Your Honor.
Okay, other than the statement by the prosecutor regarding no jail, no probation, has anything else been promised to you? Or have you been forced or threatened or coerced or had anything done to you to make you plead guilty against your will?
No, Your Honor.
All right, and you discussed with Ms. Maas all of your trial rights and you understand your trial rights, correct?
Yes, sir.
You understand that by pleading guilty, you're giving up those rights and you won't have a trial?
Yes, sir.
The conviction will go to the Michigan Secretary of State. Do you reside in Florida, sir?
Yes, Your Honor.
Okay, so the conviction will go to the Michigan Secretary of State. I think they're going to send it to Florida, and whatever Florida does with something like this, I'm assuming that they'll do. So you want to your license, you understand that?
Yes, Your Honor.
Okay, so the information then states on or about December 21, 2024, Grand Traverse County, US 31 North, that you were operating a motor vehicle, is that correct?
Yes, Your Honor.
Were you pulled over by the police or was there an accident?
Pulled over, Your Honor.
Okay, and when the police had contact with you, they thought you might be intoxicated, so they ran you through sobriety tests. At the scene, after those, you were arrested and had a blood test at the hospital, is that correct?
Yes, Your Honor.
And so the complaint indicates in parentheses, the PBT was 0.212, but sometimes that ends up being the blood test result.
Your Honor, we are in receipt of the blood test, and Mr. Rivera is not disputing that it's over a 0.17.
Okay, all right, so, and you agree with that, right?
Yes, Your Honor.
All right, so I'll go ahead and accept the plea. Again, there's no prior criminal record. The people are not objecting to going forward with sentencing. And I think you have an assessment, is that correct?
Yes, may I approach?
Sure, yes.
Thank you. So, Your Honor, I have an assessment. Mr. Rivera also completed the 8-hour alcohol highway safety program, also the victim impact panel, but we don't have the certificate for it. He has proof of completion that he texted to me.
Okay,
He also self-enrolled in counseling, so there's proof of that as well as a diagnosis and treatment plan from his counseling that he's going to.
okay, all right, I'll take a look at this. All right, so I've had a chance to review the assessment and the certificates and the treatment plan. So everything looks to be positive for you. So by way of elocution then, are there comments, Ms. Maas?
Yes, thank you, Your Honor. Your Honor, Mr. Rivera resides in Florida. He flew up here to take responsibility and come before the court and accept responsibility for the mistake he made, and it was truly a mistake. And he has since that time been on a device. He's had no issues on his daily PBTs. How often are you testing?
Once every single day between 6 and 9 a.m. for the last 2 months.
Yep, and he's had no issue He's 36 years old, he's married, he has 2 children. As you see in the evaluation, he's 100% disabled vet. He fought in Iraq as an infantryman. He has struggled with PTSD. A way that he copes with it is through work, and he works 60 to 70 hours a week. He runs a cosmetic manufacturing company in Tampa, outside of Tampa rather. And then he also has a second job as the manager of a sport clothing store. I give him a lot of credit for, he tried to go through the VA, but unfortunately it just takes too long to get anything accomplished. So he enrolled in counseling on his own initiative. He's going on a weekly basis, addressing all sorts of issues, but substance abuse as well. He'll do that for the next month and then go to bi-weekly and then eventually monthly, but he is committed to that. There's really nothing that this court could do as far as probation. I would just ask that the court allow him to leave here today with fines and costs and just continue on the path he's already put himself on.
Okay, all right, thank you, Ms. Moss. So, Mr. Rivera, are there comments you'd like to make?
No, Your Honor. I do apologize for the situation. And thank you for seeing me and allowing me to take responsibility.
It appears you're taking the matter seriously, and you understand the seriousness of an event like this, and that you're accepting full responsibility with the way you've handled it. So, and thank you for your service too.
Thank you, Your Honor.
Really appreciate that. So I don't see the need for probation, so there'll be no probation, $100 fine, $800 for cost, $75 crime victims fee, $50 state fee, there's a $125 arrest fee, and then credit for all time served. So it's a fines and cost resolution only. You can contact the court tomorrow to pay those on by phone, or if you wanted to wait today until your paperwork is processed, you could do it today, but it's either way is fine. Okay, sir?
Thank you, Your Honor.
Yep, thank you. Thanks, Ms. Moss.
Thank you.
Thank you. Thanks.
I don't think it's gonna be right.
Yes. Where are they gonna go? Billy Courtney. If you see. Thank you.
All right. Well. All right, we'll call the case of People versus Tanisha Renee Mathis, file 238866 SM1. It's a date and time of a probation violation hearing. Ms. Mathis is here in person with Mr. Hubble. Ms. Trask is here by Zoom for probation. So in terms of the probation violation, then how would Ms. Mathis be proceeding?
Well, I'd ask it to be withdrawn and allow her to be discharged successfully from probation. I just tendered a letter from her counselor at Munson Behavioral Health, and I gave Ms. Trask a copy. She's been counseling there for the last 5 months. She wasn't able to continue with CMH because she didn't qualify for their funding. She wasn't dangerous to herself or someone else. So they dropped her from the roles, but she has followed up and gotten the required counseling.
Okay. So Ms. Traska, you've had the chance to see the proof of counseling letter.
Correct. I got it just a few minutes ago from Mr. Hubble.
Okay. Well, so Ms. Mathis is on probation for embezzlement by an agent or trustee between $200,000 and $1,000. It's a 1-year misdemeanor. She's completed 3 days community service work in the theft class, which is important. She, as part of her probation, she's required to counsel with CMH, but Mr. Hubble explained why that didn't work, but she's replaced that counseling with another counseling service. Fines and costs are still out there, and I think part of that is also restitution, but that would be not be a reason to not discharge somebody successfully. All right, so I mean, it looks like at this point now everything's been completed, but Ms. Traska, any further comments you'd like to make?
I guess my only outstanding question is why it took all the way until now to get the documentation. I had been asking and asking and asking, and at one point she just stopped responding to me. So frankly, all of this could have been avoided. So I don't disagree with discharging her at this point. I'm just not sure why it was so difficult to get anything from her.
Well, I can respond to that partially. At one point in time, her position with Munson Behavioral Health, they said we wouldn't give anything in writing because their attorneys wouldn't let them or something like that. And she couldn't, because I've been asking about this to get it for months, and now I'm getting something from her stating that yes, she can confirm that she had been doing the counseling for 5 months. So it was something at their end. It wasn't that we didn't request it earlier. And I don't know what changed with respect to finally getting this, because
So I have to have something or I was going to.
so I apologize for the delay and not getting this to everybody sooner, but I think that the concern, the CMH requirement was added to her probation because some other things that were happening with her, and wanted to make sure she's getting help. I think she's getting that, so I would just ask the court to discharge her. I guess in terms of fines and costs, doesn't have a whole lot, so I'm not sure if she can work something else out with the court, but I don't suspect that she's gonna be able to pay that kind of fine or cost in this case.
Okay, so and then so we've had of course, the original sentencing here. We've had another probation violation hearing where the determination and resentence was done by the court. After that, we've had this scheduled 2 or 3 more times. But during the course of all that, we've learned that Ms. Mathis does have some, challenges going on with family and other things. So, I mean, and transportation and other things. So I think that helps also to explain the delay here. But Ms. Tresca, do you have an amount that, of the balance of restitution, which began, I think, as 523 to Big B Coffee?
She has paid a total of 450 in restitution.
Oh,
Out of the 523. So she would owe $73.
yeah, okay. All right, so this is what we'll do. I will discharge Ms. Mathis, successfully, continue the obligation to pay the final $73 in restitution. Then I'll reduce the court costs to, well, those will remain at 100. Pardon me, the fine will remain at 100. Court costs I'll reduce to 100 to help out a little bit more there, but okay. So, Ms. Mathis, I know you've totally learned from this whole thing, right? And this won't happen again, right? Okay. All right, so we're all set.
Thank you, Your Honor.
Yep, thank you. All right. So 10:30 matter, I don't see any pretrials. Take care, Mr. Hubble.
Thank you.
Yep.
Thank you, Your Honor.
Sure. All right. Okay, so this is People versus Rose Pepsin, file 24-2200 SM1. Today, time of a probation violation hearing, Ms. Pepsin, Mr. Conley, you're in person, Ms. Trask is here by Zoom for probation. So, Ms. Pepsin is indicating that she's got documentation, I think, to reflect that her child does not have unverified absences or tardies or school suspensions. Now, the correct time to present those really would have been to probation before today. It shouldn't take a probation violation hearing to get a person to do, and I'm not saying that this is exactly what happened, but so anyway, you haven't provided those to probation, right? All right. So Ms. Tresca, do you want to see these first? Or
I can send Ms. Pepsin down to, it's pretty straightforward, Judge. I mean, it might be
just easier to do it that way.
Yeah, I would agree.
And that's my point. It should have been done before today, but Ms. Tresca, we'll send Ms. Pepsin down, okay, to provide these to you. And then Ms. Pepsin, you can come back up after you present these to Ms. Tresca, and then Ms. Tresca can zoom back in and let us know whether what you have there suffices, okay? So this will handle it that way.
It still goes to downstairs.
Yes.
Yeah. So you're just gonna show her what it should be right here, this column. She can understand what that is. Okay. Thank you, Your Honor.
Yep. And do you represent Mr. Van Zale?
I do. He's on Zoom, Your Honor, so I can the jail have to go log in and break out. If that's okay.
Sure, that's fine. Can the jail be told to bring Mr. Van Zale up on Zoom?
I had him scheduled, you want him earlier, I can look at him now.
Sure.
Yeah.
Yeah.
Sure. Thank you.
All right, so Mr. Kane, you have a matter?
I've got two, Your Honor, Oscar Dean
Yeah, we're
and
ready.
Allison Wright are both set to complete after their pre-trials this morning.
Okay.
I just turned the forms in, I don't know if they're in your system yet or not.
Yes, they are. So we'll call the case of People versus Oscar Guillen, file 25-3802 SD1. There was a pretrial conference this morning. Mr. Guillen is here in person with Mr. King. Thank you. Thanks. So as you know, sir, you're charged with operating while intoxicated first, a 93-day maximum misdemeanor, and then open intoxicants in a motor vehicle, a 90-day misdemeanor. So the plea offer from the prosecutor is to plead guilty to impaired driving. It's a 93-day misdemeanor, but the driver's license sanctions are better from the Secretary of State. And then if you plead guilty to impaired, both original charges would be dismissed. So do you wish to accept that offer, sir, and plead guilty?
Yes, Your Honor.
All right. Are you on any probation or parole at this time?
Not the moment.
Okay. And you don't have a prior criminal record, right?
No, Your Honor.
All right. Other than this plea offer then from the prosecutor, has anything else been promised to you, or have you been forced or threatened or coerced, or had anything done to you to make you plead guilty against your will?
No, Your Honor.
All right. You read and signed this advice of rights form, plus you've talked to Mr. Kane about all of these rights, correct?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up these rights and you won't have a trial? Do you understand that?
Yes.
And again, the conviction goes to the Secretary of State. They'll take some sanction action as to your license, but it's, I'll just say better than if you're convicted of the original charges. Do you understand that?
Yes.
So this is a really nice resolution that Mr. Kane's worked out for you. The information though states January 29 of this year, Grand Traverse County, Rennie School Road and US 31 South, you were operating a motor vehicle, is that right?
Yes.
Were you pulled over by the police or did you have an accident?
I was pulled over.
Okay, and then when the police had contact with you, they thought you might be intoxicated, so they ran you through sobriety tests at the scene. After those, you were arrested and had a blood test at the hospital, is that correct?
Yes.
And I don't have.
0.12, Your Honor.
0.12, okay. Do you agree?
We don't dispute.
Okay, you agree with that, right?
Yes.
So accept the plea to the added count, we'll dismiss counts 1 and 2. We will need an assessment, so I'll refer the matter to probation for an assessment only. We won't get a pre-sentence report. Continue the bond. Sentencing then will be
About April 24th at 9 o'clock.
I have a sentencing in the circuit court that day for some reason. I don't know why it's on a Thursday. Do it maybe at 10.
sure.
That should be fine, yeah.
I don't know why they're having a day on Thursday rather than Friday. Okay, thank you.
Yep.
So, call that number I gave you. Call this afternoon? to
Yeah,
set up the substance use
yes,
assessment?
between 1 and 3, and that's probation's number. They'll tell you how to get that assessment done. Okay, sir?
Okay.
All right, you're all set.
Any good questions for me? I'll speak to you.
Thank you, Your Honor.
Yep, thank you. Real quick. Take time for the jail to unmute. I wanted to put Mr. Conley in a breakout room. So, Mr. Van Zale over there at the jail, we need you to unmute. I sent you a message. I don't know if you can accept that yourself, or you need to ask for help, but I want to put you in a breakout room with Mr. Conley to keep matters moving. There we go. Okay. So, Mr. Van Zale, I'm going to put you and Mr. Conley in a private virtual breakout room to talk about the probation violation hearing. It'll just be Mr. Conley and you talking. So here we go.
Thank you, Judge.
Thank you.
Judge, back to Gillen for a quick second.
Yeah.
I just spoke 0.125 on the blood results, not 1.2. So if you'd have rounded it.
Oh,
0.13.
sure.
My
Okay.
mistake.
That's okay. All right. So this is, I saw the pretrial statement. This is People versus Allison Wright. This is file 25-4004 SD. Thank you. There's a pretrial conference here. Ms. Wright is charged with operating while intoxicated first, a 93-day misdemeanor. The plea offers to plead guilty in your matter as well, ma'am, to impaired driving. Still a 93-day misdemeanor, but the driver's license sanctions from the Secretary of State are a bit better. Do you wish to accept that offer and plead guilty?
Yes, Your Honor.
All right. Are you on any probation or parole at this time?
No.
So other than this plea offer from the prosecutor, has anything else been promised to you, or have you been forced or threatened or coerced, or had anything done to you to make you plead guilty against your will?
No, Your Honor.
You've read and signed this advice of rights form, and you've talked to Mr. Kane about these rights. Is that right?
Yes.
And you understand that by pleading guilty, you're giving up these rights and you won't have a trial. And you do understand there's some sanction from the Secretary of State as your license.
Yes.
All right, so the information then states, let's see, that on or about January 25th of this year, Grand Traverse County on Cass Road, that you were operating a motor vehicle, is that right?
Correct, Your Honor.
Did the police pull you over, or did you have an accident?
I was pulled over.
All right, when the police had contact with you, they thought you might be intoxicated, so they ran you through tests at the scene. After those, you were arrested, brought to the jail where you took the Intoxilizer 9000 breath test. Is all that correct?
Yes.
And that breath test had two results, a 0.120 and a 0.109. Do you agree with those results?
Yes, sir.
All right, so I'll accept the plea to the ed count of impaired. We'll dismiss the original charge. And do you have a prior criminal record at all?
No.
All right, so,
She's got one dismissed matter and one matter that had been deferred under the domestic violence statute, Your Honor. A substance use assessment is required by law. I don't object to a pre-sentence report being prepared here in light of that.
yeah, so maybe under those circumstances, we'll do that. So we'll refer the case to probation for a pre-sentence investigation, sentencing recommendation, substance use assessment. We'll continue the bond.
Same date and time,
I can do that. Yeah.
April 24th of 10.
Sure.
And this afternoon to call probation, Your Honor.
Yes, please.
We'll call, we have a question. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Good luck, man. Oh, so you have a prelim at
I
11.
do, it's at 11.
Yeah.
That's why I like something, just stick around. It's actually, full disclosure, that was gonna be a plea.
Okay.
She's got probable cause conference plea offers to attempts on the two felony charges. She's gonna take advantage of that. Originally, that was the intent, so.
Okay, that sounds fine.
I think I can make it back. We'll try that.
Sure, that's fine.
Thank you. Mr. Olson was here about Zoom as well. Your Honor.
Okay.
Ms. Pepsin, and then the next case, right?
All right, thank you. So we'll go back to Ms. Pepsin's case. This is file 24-2200 SM1, same time of a probation violation hearing. So Ms. Pepsin now has had the chance to provide her documentation to Ms. Traska. So I guess let's check in with Ms. Traska. Does that address the violations, those documents, Ms. Traska?
It does. So this shows me, so it's giving me a breakdown of all the attendance types. So it tells me of unverified absences, it's only 1.33 days. And then unexcused tardy is 4.17. And then it breaks it down further saying for the unexcused tardy, student was late to school or class but present at school. And then for the unverified, it says not present more than 10 minutes or more than 10 minutes late. So it does look like, as Ms. Pepsin was saying, she's getting Caden to school. But once he's at school, that's where the tardies seem to come in. I will say this breakdown is much better than the attendance reports I had been getting. That's why I did the violation, because it looked like there were numerous absences and tardies. So at this point, I'm not sure, because while she's getting him to school, there are still tardies and unexcused tardy and unverified to account for. But if he's already at school, then who is to be responsible for that? That's what I'm not sure of at this point.
Okay, thank you. So Ms. Pepsin, can you work with the school officials to once your child gets to school, that they help?
I work very closely with the school. We also have doctors that work closely with in the school. Like a lot of he's in ninth grade, so he has multiple classes. I get him there on time, but
Just to help you out, Judge, a little bit, he's on the spectrum and he has had some bullying issues at school.
Yeah.
Where he has fought back against the bullies, and that is some of his in-school suspension and some of his tardiness. So mom's working with the school and his doctors to try and figure out how to help him through school without being bullied. And Ms. Pepsin indicates to me, he does have some friends that in school now, right? So things are getting better, but I would just note that last year he had 65 absences. So we're doing way better, Judge, than we were. The probation is helping. We're getting a lot better than last year.
Oh, okay, so that's really good. So what I'm gonna do is I'm gonna dismiss the probation violation. I'm gonna return this to you. But going forward, just please get school documentation to probation, so it would totally avoid something like this. But you're doing well, which is nice in a case like this, because a lot of times these cases just have a natural difficulty to them. So you're doing well, so I appreciate that. So keep doing what you're doing, okay?
thank you so
All
much.
right, thank you. Thanks, Mr. Traska. All right.
Thank you.
Do you have something? Yep, thank you.
Mr. Van Zale, Your Honor, is in the jail.
Right, so I'll close the breakout room and see if we can get him back. Two seconds, 1 second. Here we go. There he is. Okay, so Mr. Van Zale, I sent you another message to unmute. You accept that again, please? There we go. All right, so this is file 24-2506 SD1, People versus Benjamin Van Zales, date and time of a probation violation hearing. Mr. Van Zale is here by Zoom from room D. Mr. Conley's here in person. Ms. Trask is here for probation by Zoom, as well as Mr. Van Zale. So as to the allegations of probation violation, how would Mr. Van Zale be proceeding?
Your Honor, he'll be admitting to the violations with respect to the March 16th. I just want to make sure he's admitting to being arrested for that, not to having committed it. I explained to him not to discuss any alleged facts in that matter. So
Okay, very good. So we could start with the March 16 allegation that you were arrested for domestic violence. You agree with that, right, sir?
Yes.
Okay, that's all you need to say. And then
Okay.
as to the other violations, you've been through them now with Mr. Conley. Can you admit that the balance are all true probation violations as a group, or do you want me to go through them individually?
I understand you can just, I agree with admitting to them, as a group.
Okay. All right, so I'll accept the pleas. In terms of sentencing then, are there comments, Mr. Conley?
Yes, sir. I wasn't the underlying attorney in this matter, but it's an impaired driving sentence. And he indicated to me he didn't have any other criminal history. Is this his first conviction?
Well, in 2008, in the 89th District Court, there was impaired driving. Also in 2008, also in the 89th District Court, there was a possession of marijuana, which was disposed of by 7411, which would mean that was a successful probation. Actually, there isn't a conviction for that, so.
So I guess, Your Honor, this probation hasn't been going on very long, and obviously I understand why there's reasonable recommendation for termination based on the number of violations in a short period of time. I guess the question is, Your Honor, what is the sufficient time figure for an impaired first? What jail figure Your Honor feels appropriate? Because I can see why they don't want to continue probation. I think Mr. Van Zale is amenable to not being on probation any longer either. Unfortunately, it looks like he's likely to have bond conditions in another case coming up based on the allegation on the 16th. So he may be right back in the same situation again with respect to bond terms. And obviously he'll have to comply with those. If he doesn't, then the same thing will happen with lack of following probation terms. So.
Do you know what the bond is in that case?
I don't. Have you been arraigned yet, sir?
No.
So yeah.
But bond can and usually is set on those cases before arraignment. Did you go before the magistrate by video to have your bond set in that case, sir?
I'm not sure that I did. I don't believe so. I might have because I did see a magistrate, but I'm not totally sure what it was exactly for. She did set a bond for $50. And she also said with time served in that meeting, but I wasn't exactly sure what what that was pertaining to because there was so much coming to a head all at once. So.
All right. Well, it sounds like that she set a $50 bond on that case. Okay. Anything you'd like to say here, sir?
I just those probation violations, I was at a really bad time for me, and I was really depressed, and I was just kind of in a huge funk, and I've since been on some Lexapro medication, and it's really been helping things turn the situation around for me, and I'm in a lot better place mentally than I was during that time. So I just would like to say that.
All right. So how long have you been in jail?
14 days.
All right. Are you working, sir?
I mean, right before I came in here, I had some pretty for certain leads on job starting. That was Monday, but that happened on a Sunday. So I mean, hopefully if say everything goes good and I was to get out, then I think that I would probably have employment as soon as I get out of here. Yeah.
And then what's your living situation? Who do you live with?
I'm living just with a friend right now at his place, and that was all very new because I was in the process of trying to move out of my other place. Yeah, I mean, I have a place to go, and live, but I just started kind of paying him money to live there, and it's all very new. So
All right. So I'm sure the new bond has a no contact provision and also a provision that you not return to the place where the case allegedly occurred. Is that right?
I'm guessing probably, yeah. I'll stay very far away from all that for sure. I do have things that need to be moved out of there, and I don't know how that'll all work out, I guess, but I guess I just wanted to mention that.
You can talk to Mr. Conley about that. Do you represent him on, well, he hasn't been around yet.
Right, yeah. Mr. Johnson looks like was his underlying attorney, maybe in previous
Okay.
underlying matters.
So talk to the attorney that represents you in that new case, okay? And that person will help you figure out how to get your things.
Okay, all right.
So I agree with the recommendation. I don't see that continued probation is going to be helpful here. So I'll revoke probation. Jail sentence will be 21 days credit for time served. So you'll be out soon, okay, sir? And I'll just note too that this is an impaired first with low BAC. I understand he didn't comply with probation, and there's one prior conviction in 2008. And of course, the new case is presumed innocent. So that's where we are. So you're all set, sir, okay?
Okay, can you just confirm on what exactly you just said there? Like what do we?
So the sentence is 21 days. You have credit for 14, so that would reduce the sentence to 7, but I'm guessing you're gonna get a day or two of good time on that 7. So it could be just roughly 5 days, okay?
Yeah.
All right.
Oh, okay, 5 more days that I'm in here?
Yeah. Correct.
Okay.
But ask the jail. They'll have an accurate tally of your time, okay?
Okay.
All right.
And then
So well
one
said.
other thing, can I ask you?
Sure, go ahead.
And then would probation be done for the impaired, or do you?
Yes, probation's done. Your fines and costs though are preserved, which means you still have to continue paying on those, okay?
Yep, I got you. Okay.
All right.
Sir, when you get out of the jail, when you get out of the jail, you better check your bond conditions for your new.
His DB was actually declined.
Oh, there is no new one.
Yeah.
Okay, all right, so there is no other case right now, sir. You're good. So when you get out, you're out.
Oh, okay.
Okay.
So you're not being charged with domestic violence. So as soon as your remaining time is done here, then you're all set. You're off probation and you're not charged with anything else at this time, okay?
Okay, cool, great, thank you.
All right, thank you. Good luck. Thanks.
Okay.
See ya.
Bye-bye.
Bye-bye. Okay, so I'm gonna give that to you. So, Mr. Graff, do you have good news for us on Cornell Berg?
That's good news, Your Honor.
That he's here. He attended his pretrial this morning and he's here for his prelim.
Unfortunately, that is not good news I'd like to share.
Okay, so you haven't heard from him since, well, he was here Tuesday, just to back up. Or Mr. Graff was here, the case was set for prelim on Tuesday. Mr. Berg didn't show. We decided to adjourn until today because he had a pretrial also this morning. We were hoping he would appear for both, but, and you haven't heard from him since Tuesday, right?
Actually, I have.
Oh, you have?
That's why I'm even more disappointed. I contacted him. I tried to call and tried to email. And he did receive my message. And at 12:15 on Tuesday, March 25, his last response was, "Okay, I will be there." So I was expecting to see him this morning. I told him at 9:30, so I did see on the docket there's an 11 o'clock. I don't know if he would have had notice or been aware that the 11 o'clock, so I'd be surprised if he showed up. But in his prior message to me at 12:13, there was indication that he had been waiting in the Zoom. And so I don't know why he would have waited for over an hour and not said or done anything, but.
Yes. And that was Tuesday?
Correct. But anyway, the last I heard, he indicated he was going to be here. I So I tried calling the last number I had for him. And message, sent an email this morning too.
Okay, well, it's positive. I guess he got back to you. It's just 11 o'clock now. I suppose we could give it a few more minutes or.
If the court's inclined, I'll give him the benefit of the doubt. No, I can wait
Okay,
a couple of minutes. If that's okay.
sure, that's fine because we have another case to go. Oh, and I think it's ready. So we'll call the case then of Kendra Danielle King, file 228156 FY. It's the date and time of the preliminary examination in this case. Ms. King is here by Zoom. Mr. Kane is here by Zoom as Ms. King's lawyer, and then Mr. Olson is here in person for the people. All right, so this looks like it's going to be a misdemeanor resolution. Is that correct, Mr. Kane?
Yeah, that's correct, Your Honor. At the probable cause conference, Ms. King was offered an opportunity to plead to two misdemeanor counts of attempted FTD, stealing, retaining without consent. She would like to take advantage of that opportunity and do that rather than proceed with the prelim today.
Okay, so we do have that in writing. Ms. King, then, let's see, you're unmuted. You wish to plead guilty then to 2 counts of misdemeanor, attempted unlawful use of a financial transaction device, each a 1-year misdemeanor, and in exchange, the 2 original 4-year felonies would be dismissed. So do you wish to accept that offer, ma'am, and plead guilty?
Yes, Your Honor.
All right, are you on any probation or parole at this time?
No, Your Honor.
Other than this plea offer from the prosecutor, has anything else been promised to you, or have you been forced or threatened or coerced, or had anything done to you to make you plead guilty against your will?
No, sir.
All right, and you've discussed all of your rights to trial with Mr. Kane, and you understand your trial rights, is that correct?
That is correct.
And do you understand that by pleading guilty, you're giving up those rights and you won't have a trial? You understand that?
Yes, I do, Your Honor.
All right, so then the information states the relevant date is the same date as to each charge, September 6, 2022, Grand Traverse County. The address in the complaint is 1709 Ewing Street, Grand Traverse County, that you did knowingly and without consent use, possess, retain a financial transaction device belonging to Michelle Denise Burking and Alan Michael Habit. So are those basic facts correct?
Yes, Your Honor.
All right, so then can you tell me with some detail what you did here? So how do you know these people, if you know them? How did you get a hold of their cards, and what did you use the cards for?
My ex-boyfriend and I lived with them. We rented a room from them, and they were quite the drinkers, and they would ask us to take their card frequently to the store, which was right up the road, and buy them alcohol, cigarettes, whatever else they wanted at the time. I at times would buy extra stuff, cigarettes for myself. I took out cash on occasion for the ATM when they asked me to take out cash for them. And I did also buy lottery tickets.
Okay, so you bought cigarettes, you took out cash and bought lottery tickets for your own purposes, right?
Yes, sir.
All right, and you did not have the permission of Ms. Burkeen or Mr. Habits to make those purchases for your own purpose, right?
Not every time. They did give me permission from time to time, but not all the time. I did some that on my own.
As to both cards, right?
Yes, sir.
All right. So do the attorneys agree that's an adequate factual basis, or is there anything else we should inquire about?
I would just inquire, Your Honor, on that this occurred in Grand Traverse County.
Okay, I think I did say that, but you use the cards in Grand Traverse County, right, ma'am?
Yes, sir.
Okay. All right. so
Nothing
I'll
further
accept
from the
plea.
defense, Your Honor.
Okay, thank you. I'll accept the pleas to the added 2 counts to dismiss the felonies. Or refer the matter to probation for a pre-sentence investigation, sentencing recommendation, restitution inquiry. Continue the bond. Sentencing then will be,
What about April 25th at 9 o'clock?
I don't have anything right now. That should be fine. That should be fine. Thank you.
all right. So then the only other thing, ma'am, is I have to give your probation's phone number so you can call them this afternoon. Can you write this number down?
Yes. Yes, I can.
Okay, it's 231 922 6899.
Okay.
So
Is there an extension?
what did you say? I didn't hear that, ma'am.
Is there an extension, sir?
No, that's probation's general number. They'll be expecting your call. Just let them know you were in court today, that you accepted this plea offer, and they'll take it from there, okay?
Okay.
All right. So for now, you're all set. Bonds continued. So feel free to sign out. So thank you.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you.
Kendra, if you have questions, feel free to call.
Okay, thank you.
Thank you, Your Honor.
Thank you. Mr. Bird.